So, without further ado, I'll introduce you to our first speaker, Valencia Abbott. And to give you a bit of background, Valencia is the Social Studies Department Chair and History Teacher at Rockingham College High School, in Wentworth, North Carolina. And after completing a master's degree in liberal studies, Valencia received a post-baccalaureate certificate in African American Studies at the University of North Carolina at Greensboro. And in 2016, Valencia received an add-on licensure in academically intellectually gifted from Duke University. Valencia has served in countless education advisory boards, far too many for me to list tonight, but is currently serving on the Carter G. Woodson Book Award Selection Committee and the iCivics Educator Network. Valencia is also a board member of the Professional Educators of North Carolina, chairperson of the Education Committee of the Reidsville branch of the NAACP, as well as being an integral part of MARC's programming committee for the past few years, and we are extremely lucky to have Valencia. So welcome, Valencia. Thank you for joining us tonight, and really as one who spearheaded the whole research of this project for the past several years, and has approached it through the kind of lens of an educator. I'm sure plenty of people will have questions throughout this and be intrigued with your journey of discovery. So I will hand it over to you.
All right, thank you. Thank you for that introduction. And thank you to all that's in attendance of this special occasion in commemoration of the 50th anniversary of the United States Supreme Court decision of Griggs versus Duke Power. In the fall of 2018, I set a countdown timer to this date. With hundreds of days to go, I knew that it would come quickly and it would be here before I knew it, and it is. And we're here at this moment. On this date, my thoughts are with those 14 men who signed that statement in 1966 and wondered what their day looked like 50 years ago when the Supreme Court decision was made. Was it a typical workday with their shift, or did it come with recognizing the triumph of a 5-year journey that had embarked on? Or was it spent in reflection of prayer, just as others of African descent had also uttered with injustices that was placed upon them? We may never know exactly, but we do know that the legacy that the plaintiffs of the Griggs versus Duke Power Company case, 1971, forever changed them and our country. This evening, my purpose is 3 things: to give a quick summary of the Griggs versus Duke Power case, explain why we got here with the commemoration, and teach why it's important. I title my project The Civil Rights Movement Beyond 1968, Griggs versus Duke Power Company, because many believe that the civil rights movement ended with the assassination of Martin Luther King Jr. But the truth is that the fight for equality, equity, and justice did not begin in the 1950s, nor did it end on April 4th, 1968. The fight for civil rights took many forms, and one of them was when 14 African-American men signed a statement on March 3rd, 1966, to their supervisor that read in part, "We, the employees of the Duke Power Steam Station, Draper, North Carolina, wish to issue a complaint of discrimination because of our race against the company. On the first day of March, 1966, we request to be considered for a higher paying classification when, as whenever, a vacancy occurred in higher classified jobs." They signed this piece of paper not knowing if it meant losing their job or losing their lives. They signed this piece of paper when it put their families in jeopardy. They signed because they knew it was right. And most importantly, they signed with courage. This case is about employment discrimination And Professor Tompkins will later speak to us about the implications and significance of that part of the case. Me, as a history teacher, as someone that was born in Rockingham County, North Carolina, and the soil of Ruffin makes me who I am, I see this case as the understanding of where I come from. I see this as the people that I grew up with and grew into. And the understanding that when I'm telling their stories and hearing their voices, I achieve the ability to meet challenges and the courage to make the changes and choices of the world I inherited. This gets me to the 50th commemoration, and that is because of the Museum and Archives of Rockingham County. All the people and pieces that had me sitting in that planning committee at the museum, trying to come up with ideas for programs. Then the museum executive director at that time, Jordan Rossi, mentioned the Griggs case. It was a point of history that I was vaguely familiar with. I remember that evening after the meeting, for some reason, that thought of that point of history would not leave me. Going home and doing the math and research and realizing that the 50th would soon be here. It was known then, and more so now, that I could not let this occasion pass, this day, without amplifying their voices, without revealing this hidden history. It has been 2.5 years of bugging everyone I know to help me locate family, visiting cemeteries, genealogy research, hearing stories, and making connections. It has been a humbling experience with tears as some family members shared memories of their fathers or grandfathers. It was a revelation of sharing this information with others that their uncle, daddy, or grandfather was part of the United States Supreme Court case, and they're hearing about it for the first time. Being so touched when the granddaughter of Robert Jumper, Val Adams, shared that she heard about this case in 1987 as a freshman at North Carolina State in a Supreme Court and public policy course. And that Griggs versus Duke Power was on the list. She chose the case because she recognized the family name and she knew of Duke Power. This gets me to the why. Interviewed on July 1st, 1971, just one day after the conclusion of the Supreme Court's 1970 term, Chief Justice Warren E. Burger was asked to name a case or two to stand as a landmark from his first 2 years on the court. Rather than citing either the Pentagon case, which was just issued the day before, or the famous school bus case, which was handed down on April 20th, Burger instead responded that I think there is one case that has been commented on a great deal by others as have been a sleeper. It was Griggs against Duke Power Company, having to do with equal employment opportunity. This goes beyond this landmark status and sets with the fact that a granddaughter should not have to sit in a college classroom to learn of her grandfather's legendary steps. We should not have to wait 50 years to hear the stories or know the history. This history should be in our textbooks, in our curriculum, and in our hearts and minds. Last summer, in the turmoil of the empowerment of the Black Lives Matter movement, there was a saying, "I am not my ancestors." I thought that was so disrespectful. Then I realized that way of thinking was because many people do not know the histories nor the stories. So tonight, we will know these ancestors' histories and parts of their stories. I am my ancestors. Willie Griggs, James Tucker, Louis Hairston Jr., Willie Boyd, Junior Blackstock, John Hatchett, Clarence Purcell, Eddie Galloway, Eddie Broadnax, William Purcell, Herman Martin, Robert Jumper, Clarence Jackson, and Jesse Martin. I've titled him the 14th plaintiff. I honor their names and give reverence to and for them. Thank you. I just want to say that at the beginning, I put a link to a presentation. I'm always the teacher. I'm always thinking how to commit something to make it a lesson plan. So I've created this presentation. It's geared towards teachers, but anyone is more than welcome to review the information. It has sources, it has links. I wanted teachers to start thinking about how we're going to get this into the classroom. And how we're going to understand. We have to understand this history ourselves. But one of my goals is to get this lesson plans into the curriculum. So the link is there with that. So please feel free to make a copy and to use it as you are inspired.
Well, I was saying thank you, Valencia, before Zoom so rudely cut me off.
That's all right. I'm a teacher. I know how to fill in some airtime, so I'm good.
Yeah, technology is great when it works. But thank you so much. I'm sure you'll get a few questions and hopefully make a few more connections from that. But that was fantastic. Thank you. And so now it's my absolute pleasure to introduce you to our next speaker, our headline speaker for tonight's event, which we are incredibly lucky to have as well, Cynthia Elaine Tompkins. And to give you a bit of background, Cynthia is an attorney, writer, public speaker, and scholar of race and American legal history. She's also a professor of law and founder of the Center for Dialogue to Build Community. So yes, I will carry on. I think I got up to some of Cynthia's publications as well, and Cynthia's Bachelor of the Arts degree in sociology from Wake Forest University, and Juris Doctor degree from the University of Cincinnati and College of Law. In addition to her current work as professor, speaker, and writer, Cynthia has served as Deputy and Assistant General Counsel for the federal agencies in Washington, D.C., Assistant United States Attorney for the Eastern District of North Carolina, Attorney for the United States Department of Justice Civil Rights Division, National Church Arson Task Force, and Assistant District Attorney in Philadelphia, Pennsylvania. So I really hope I didn't miss anything off there. I'm sorry I cut off partway through there, Cynthia, but thank you so much for joining us tonight.
You didn't mess anything up with you, and thank you very much for the very kind and nice introduction. Good evening. Tonight, first, I'm going to just make sure my volume is fine. I'm going to cut it up just a bit, and I will say good evening to everyone here. I am honored to be here tonight to discuss this very important United States Supreme Court landmark case of Griggs versus Duke Power Company. Now, here's how I want to structure this tonight. I recognize that I teach law courses, so I teach to students who are aware and study the law every day. So they're very aware of case law, case facts, the issues, the rules, the analysis, and the conclusions. But I would like for this discussion this evening to reach everyone here from ages 5 to 95 or older. And my point is that I'm going to structure this in the form of a narrative this evening so that I will hopefully be able to break the case down where everyone will understand it. Furthermore, I think that it's important before I get right to the Griggs decision, and I believe I have about 30 minutes this evening. So I'm going to absorb that time by giving a foundational history of some of the historical facts related to race and the history of American law. Now, why is that important? I am a firm believer that unless we understand historical points and we firmly know our history, we can't understand present events or some recent past events. So in order to fully grasp and understand what happened and what led to the need for a Supreme Court case entitled Griggs versus Duke Power Company, it's very important that we have a few background facts. So I would like to begin tonight at that place. My first point would be to say that the struggle for workplace equality and equal rights in the United States of America began in the Jamestown, Virginia colony, not in Rockingham County, North Carolina. That struggle actually began in the Jamestown, Virginia colony in 1619, when the colony's secretary and recorder, John Rolfe, said to the people there in the colony on one summer afternoon, he said that he saw a ship sailing into the Chesapeake Bay. And he said a Dutch man of war stepped off of the ship. That man's presence was very likely underwhelming. But what happened next changed the course of history and set in motion centuries of marginalization and discrimination in the United States of America. For John Rolfe, that secretary and recorder in the Virginia colony, his records confirm that the Dutch man of war brought 20, and I quote, 20 odd Negroes, unquote, to the Jamestown colony. Now, Negro was the word used in earlier centuries to refer to Black people. The Africans who arrived that momentous day were brought to the Jamestown colony by force, not by choice. And while it is reported that Africans were brought there in 1619, it is well known that Africans first came to the United States as early as 1400. But it was in 1619 that they arrived in the British English colony in Jamestown, Virginia. Liberty, individual freedom, and fundamental human rights were the ideals that caused the English to leave England a decade or so earlier than 1619. In about 1607, they left England. Nevertheless, those Englishmen, contrary to the principles of liberty, the people from Africa were enslaved for 246 years until the institution of slavery ended after the American Civil War and the 13th Constitutional Amendment was added to the Constitution in 1865. And in the years that followed, American Southern states in particular were segregated. Black people were disenfranchised, terrorized by supremacist groups, and faced discrimination in education, housing, public accommodations, employment, and nearly all segments of society under unjust laws enacted in the Southern states. Indeed, the Supreme Court declared in the 1896 Plessy versus Ferguson Supreme Court decision that separate facilities for Blacks and whites were equal. That court decision empowered segregationists so that overt discrimination began to increase even more after the Plessy versus Ferguson 1896 decision throughout the South. Plessy was later denounced by the Brown versus Board of Education decision almost 50 years later. But segregation's Jim Crow laws enacted remained in effect for several decades later. It was indeed a segregated society, especially in Southern workplaces. Seeking new opportunities and exhausted by the oppressive Jim Crow laws, many Black citizens began to migrate from the South. They moved mostly to northern states to escape segregation, the terrorism, and the unequal employment opportunities. But despite the great migration of Black people out of the southern states, as educator and civil rights activist W.E.B. Du Bois once said, and I quote, "The future of Black Americans is in the South. Here they have made their greatest contribution to American culture, and here they have suffered the damnation of slavery, the frustration of Reconstruction, and the lynching of emancipation. Here is the magnificent climate. Here is the fruitful earth under the beauty of the southern sun. And here, if anywhere on earth, is the need of the thinker, the worker, and the dreamer. This is the firing line. I repeat that last sentence. W.E.B. Du Bois said about the South that it was and is the firing line. Now, what did he mean by that? Literally and figuratively speaking, for workplace equality, workplace equality began on that firing line in 1965. And it began there, on that date, because that was the effective date of civil rights employment law legislation to address discrimination against Black Americans. In the year 1964, after more than a decade of civil rights marches, protests, and petitions for civil rights, Congress passed landmark legislation, possibly, in my opinion, the most landmark legislation ever passed. It was the Civil Rights Act of 1964. President Lyndon B. Johnson signed that legislation into law on July 2nd of that year. It was enacted to address the broad range of discrimination that African Americans had encountered for centuries in America. And it was enacted to end the Jim Crow system of segregation. Title VII was one of the 11 provisions of the 1964 Civil Rights Act. Please understand that no other constitutional amendment, earlier state statute, or federal legislation had been able to adequately address the widespread discrimination that Black Americans had faced during the years of slavery, segregation in the workplace, or at any time in American history to that date. There had been no legislation that could prevent that discrimination that occurred mostly also in the North, but mostly in Southern workplaces. But Title VII, that employment law legislation, which was the seventh provision of the Civil Rights Act of 1964, prohibited employers, employment agencies, and labor organizations from discriminating against any individual based on race, color, religion, gender, or national origin. In addition, Title VII also prohibited discrimination in all aspects of employee, which included job advertisements, recruitment, applications and hiring for positions, job assignments, promotions, and pay benefits, and a few other provisions as well. That impactful law applies to all government, and here is a key point, and private employers that have 15 or more employees. Prior to that landmark act, one of the reasons I say it's so impactful is that there had been a constitutional amendment put in place in the year 1868, and that was the 14th Amendment. You may hear about that a lot. The 14th Amendment does indeed guarantee due process under law and equal protection under law. However, it had many challenges when African Americans tried to bring lawsuits to say they were being discriminated against in public accommodations, universities, colleges, employment under the 14th Amendment. Much legislation said that it would not work for private employers. So decades, I gave you this history because I want you to imagine when we think of these 13, or as the history teacher, Mrs. Abbott, said, when we think of these 14, it was 13th plaintiffs named, but she has recognized 14 because of one other employee's involvement, yet never getting recognition. But there were actually 13 who were named plaintiffs. When we think of those courageous men, and quite frankly, all the men, women of that generation, we have to know that all those years of marginalization, discrimination, and racism had never been stamped out. Nothing could stop the atrocious acts until this legislation came about. So here's what happened on the night of the legislation. President John F. Kennedy had proposed the Civil Rights Bill before his untimely assassination. He had stated in 1963, before it was enacted, that the legislation was written to deliver the promise of racial equality for African Americans. Kennedy, regrettably, did not live to see the law enacted. But within hours of the Civil Rights Bill's passage on July 2nd, 1964, you could feel the jubilation. Many congressional House members and almost all the members of the United States Senate, except Southern senators, they entered the White House to join with members of the executive branch. Dr. Martin Luther King was there, King Jr. was there, and many other civil rights activists. It had been almost 100 years since the abolition of slavery, when President Lyndon B. Johnson addressed the nation before signing that Civil Rights Act. And here's what President Johnson said, and I quote, he said, "We believe that all men are created equal, yet many are denied equal treatment. We believe that all men have certain unalienable rights, yet many Americans do not enjoy these rights. And we believe that all men are entitled to the blessings of liberty, yet millions are being deprived of those blessings, not because of their own failures, but because of the color of their skin. The reasons are deeply embedded in history and tradition and the nature of man," meaning what's in the man's heart. "We can understand," he said, "without rancor or hatred, how this all happened, but it cannot continue. Our Constitution, the foundation of our republic, forbids it. The principles of our freedom forbid it. Morality forbids it. And the law I will sign tonight," President Johnson said on July 2nd, 1964. He said the law he would sign that night forbids it, unquote. And he said much more, but that's a summary. With that statement and new federal law, that civil rights legislation, it should have been a new beginning with increased job opportunities and equal rights under the law for African Americans in the workplace and throughout society. But Southern companies, state governments, and entities continue to operate with dishonest practices. Perhaps one of the most notable and grotesque examples of the persistent refusal to stop discriminatory practices occurred right here in the North Carolina Duke Power Company plant. In the Duke Power plant, to circumvent or get around the requirements of the new landmark civil rights legislation, which prohibited employment discrimination, on the exact same day that the Federal Civil Rights Act was signed, July 2nd, 1962, the exact same day that President Johnson signed that legislation, Duke Power Company added a requirement to its employment rules, stating, and I quote, "Henceforth, placement in any department but the labor department would require both a high school education and a satisfactory score on 2 professionally developed aptitude tests." Now, they put in place a new requirement because there was a new law, and the company was what I call crafty. And crafty, never let anyone compliment you by saying you're crafty, because crafty, the definition of it is deceitful, sly. And that's what they were. They were crafty because they decided, okay, the federal government has passed new legislation that says that all men are created equal, that Black men will no longer have to work in the labor department, that they might just get an opportunity to rise up, to have more money for themselves, their families. They might just get an opportunity to this American dream that the British had fled England seeking: life, liberty, the pursuit of happiness, justice for all. Duke Power said, I think not. We will put in place this very day. While Johnson was signing the legislation, they said this very day, we will enact legislation not enact legislation, apologies. They said we will impose in our handbook, in our job requirements, that there be an aptitude test, two, that every employee must pass to either gain entry in certain departments outside of the labor department. No requirements there, because almost like slavery and Jim Crow, they wanted those Black men in the labor department because no one else wanted those jobs. I spoke with one of the plaintiff's daughters who I've been interviewing for a personal story we will tell in a forthcoming publication by my center in the next couple of weeks. And she told me how her father used to come home, Brenda Matthews, Junior Blackstock, was maybe the first or one of the first employees there in 1948. And she said he used to come home with coal or smut all over his body. So it was not the desirable position. And they made much less than anyone else in any department. But Duke Power had decided on the same date, the reason I gave you the history leading up to July 2nd, 1964. 1964 was the signing of the legislation, and the history of that date, by July 2nd, 1965, I misspoke on one point. 1 year later, they would have to have new rules in place for this requirement. It was on that date that in Eden, the plant had been divided into 5 operating departments: the labor department, the coal handling, the operations, the maintenance, and the laboratory and test. Before 1965, and I want to correct one thing, I was saying 64. 64, the Civil Rights Act was enacted. 1965 was the date that was given that employment, the EEOC, which is the Equal Employment Opportunity Commission, which would oversee all employment, private and government employment. It would be the regulatory body. So they had 1 year to do this. So 1 year later in 65 is when rules were put in place. Duke Power had previously in 1955 put in place an high school requirement test. You had to have a high school diploma. So that had been put in place already. But then they added to that the aptitude test. This was beyond what we would call today implicit bias or unconscious bias, meaning that it was a bias put in place to hold Black people back even longer. Previously, their discrimination had been blatant, overt, but now it was more implicit or not easy to prove. And that's where the difficulty comes in, which brings me to the case. So after doing that, and I would like you to recall, some might be thinking, well, why is it so difficult? And why is it a problem for an employer to say, if you're going to move to higher departments where you're paid more, your responsibilities increase, it requires more talent, aptitude, and skill, why not have aptitude tests? And why not have a high school diploma? See, that's the difficulty in the law. Because with the new aptitude tests and the high school diplomas, recall that Black people, it seems like a long time ago, but slavery didn't even end until 1865. From 1865 until 1964 and 65, there was Jim Crow segregation. Segregation did not end until 1964. Plessy versus Ferguson had said separate was equal, but separate never was equal. Facilities, quality of education, job opportunities, living conditions, everything in the South for most white people were better than for many and most Black people. As a result, most of these Black men did not have a high school education, and those that did knew that they might not be able to pass the aptitude test. So here they have new laws that raised their hopes that they would get out of this labor department and make a better living for themselves and their families, but yet they knew that they may never be promoted beyond the labor department. Now, here's where the courage came in, as Mrs. Abbott said this evening. Those 13 men finally came together and decided that they would challenge Duke Power's action. The difficulty in challenging the action was that this case is about how do you prove employment discrimination? And this is the difficulty where people don't always understand the case. It's not a case about anything except how to prove an employment discrimination case. I'm here to tell you that Congress enacts laws every year, sometimes 2 and 3 times a year. It's up to the regulatory organizations and the courts to decide how those laws are presented and how those laws are interpreted. So it was confusion in how do you prove employment discrimination? Good, we have the laws, but now how do you prove it when a company has what appears to be a neutral policy? Neutral, meaning that they didn't say that all Black employees would have to have a high school diploma, which was already a requirement since 1955. And they didn't add to that only Black employees would have to pass 2 aptitude tests. Instead, they made that requirement for all of the employees who were currently there and those coming in. Coming in, if you were joining the company from the outside, you would have to have the high school diploma and the aptitude test. They decided it only needed to be the aptitude test for promotion for those who were already there. And that was done because some of the white employees started to complain that they didn't have a high school diploma. So to get them promoted, they reduced the requirement for the people who were already there, the incumbents, and said, okay, you just have to pass the aptitude test. So how did this play out? If it's a neutral policy, how do you prove that? How do you show that there's discrimination when it seems that the policy applies to everyone? Well, there are 2 ways to prove an employment discrimination case. The first is intentional discrimination. And then the second, which came about in this case, because of those 13 brave plaintiffs, if not 14, that Valencia Abbott mentioned earlier. The second way is through a disparate impact. So the first would be intentional. Here's an example of intentional discrimination. Let's say I work for a company and I want to go, remember I said that the act covers discrimination in hiring, promotions, firing, training, all areas. Well, let's say I would like to go, I know that I'm going to be a better attorney if I receive training and continuing education. I'd like to go on trainings at least once a year to a conference where I'm going to get better training. And the best trainings happen to be maybe in Hawaii. And that my colleague, who's a white male, is constantly going on that training in Hawaii, not to mention the beautiful place. But I am constantly sent every year to a training in Paducah, Kentucky or somewhere in the hot heat of the summer with no scenery, small little place, not even great restaurants, perhaps. No offense if anyone is from Paducah, but I don't know of any good restaurants there beyond just not like Hawaii. But the point I'm making is I would have good reason to potentially file an intentional employment discrimination suit because someone who's in a similar position as I, we're both lawyers, we both hold the same education. If we both had been with the company for a certain period of time, we'd have a good case to bring to say that I'm being intentionally discriminated against because I'm not receiving the same level of continuing education as my colleague who's similarly situated. Now that's intentional discrimination. But again, what happens in a case that you have where there's just neutral policies? Well, in 1965 to 1970, no one had considered how you prove this. It didn't happen in New York that they brought plaintiffs, nor did it happen in somewhere in Florida or anywhere else. It happened right here in the Eden, North Carolina, that these 13 men decided that they would get together with an attorney named Julius Chambers, who was one of the first Black lawyers to really acclaim status here, achieve status in the state of North Carolina. And Julius Chambers worked for the NAACP, Legal Defense Fund. He and a few others, Robert Belton and many other great lawyers, talked to the gentleman, worked with them, and they brought this case. Here's how the procedural history took place at different levels of the process. Well, it began in the lower courts. The first case, when they filed suit, went to the district court. It was a district court in the state of North Carolina that held that the Duke Power Company's overt racial discrimination had ended when the Civil Rights Act became effective. So the court at the lower level decided that because the act was really written for the future, no relief could be granted to the petitioners, the plaintiffs. And what that means, let me break that down, is that the lower district court had essentially said that any overt discrimination had been eliminated by the Civil Rights Act. They were saying that this is a neutral policy. And they were also saying the men cannot prove that there was intentional discrimination. So there's no case. Well, fortunately, those lawyers, Attorney Chambers, Belton, and the others, decided to appeal the case. The next level process, the reason this all started in right after 1965 and was not decided until 1971, it takes a long time, a lot of courage, and a lot of discipline to let a case move through the process, and a lot of bravery on the part of these men, because in the late 60s and 70s, their lives could have still been endangered by bringing suit against a major company at such a time as that. So after they lost the district court case, the case was appealed to the Fourth Circuit Court of Appeals. And they reversed in part, but not fully. And what that means is the Fourth Circuit, which is an appellate branch here in North Carolina, and is also oversees Virginia also. And the Fourth Circuit Court of Appeals held that the act could reach past discrimination, disagreeing with the district court. It said it could reach past discrimination, that because the high school diploma and the aptitude test applied to all races, there was no violation of the act. So I've already explained that. That's where the neutrality came in. They said it's a neutral policy. Unlike the district court decision, yes, it can reach past discrimination. But since it applies to everyone, so said the Fourth Circuit Court of Appeals, there's no violation of the Title VII of the Civil Rights Act of 1964. They didn't give up. They were brave men. They had good lawyers. And they said, let's appeal this. What do we have to lose here? Let's give it a shot and ask the Supreme Court if they will hear the case. And the Supreme Court of the United States of America decided to take this case from these men who were laborers in a company in a small place, Eden, North Carolina, formerly known as Draper, now Eden, North Carolina, in the Dan River Duke Power Company. The issue that went before the Supreme Court was, does the Civil Rights Act prohibit an employer from requiring a high school diploma and satisfactory scores on aptitude tests for job advancement when the tests are not specifically related to job performance? So they were not specifically, according to the plaintiff's attorneys, Mr. Chambers, Belton, and others, that the tests were not even specifically related to job performance. And their second contention was that the tests would disqualify African-American employees. It did at a higher rate than white employees. That second part is where the new theory started. And that theory was called the disparate impact theory. It is taught in law schools all over the United States. And I want the family members and all people here tonight to understand something. Before I joined the Legal Academy and became a professor of law, I practiced law for over 20 years. As a practitioner, having many cases that dealt with employment discrimination, every time I stood in the courtroom, and recognized a case that dealt with facts similar to Griggs versus Duke Power under the disparate impact or disparate impact theory. I remembered the 13th plaintiffs. I remembered that they were from my home county. Their courage, their tenacity, and their determination to make a better life for themselves and their families. Disparate treatment, the example I gave, Hawaii, Paducah, Kentucky trainings. I'm individually impacted in treatment there. These men filed a class action, meaning they joined together as a group, and their attorneys argued. The second and main part of the argument was that their job performance and their disqualification under the job performance of these employees was happening at a higher rate than white employees if this aptitude test and the educational requirement stayed in place. So that's what you hear a lot in the news today. You hear about disparities that impact Black people, that Black people are more impacted in one way or another by the disparities that exist. This is an example of it. It's not an easy case to prove. It requires statistics. It requires very strong evidence to show that there is a greater impact, negative impact, that's impacting in this case, Black people. The Title VII law, when it says race, it applies, by the way, just as a point of law here, understand this, it applies for anyone. You could be in an organization and say you're being discriminated against because you're white, Asian, Hispanic. All those areas qualify as well. But in this case, these were African Americans, and it had a disparate impact, not treatment, not disparate treatment, but a disparate impact on them. So when it got to the Supreme Court heard the case, and the Supreme Court in an 8-0, there was one recusal, an 8-0 decision from those justices. They found unanimously in favor of the plaintiffs. That's remarkable. I pause there because I can never teach this case or talk about it and think about how remarkable that was. How remarkable it remains today, 50 years later. Now, I'm not going to sit and tell you that there have not been many challenges to Griggs versus Duke Power. There are scholars who write about the problems with the case and the theory all the time and the concerns with it. But it is still good law, and I hope that it will be for a long time, and I'm hopeful that it will not be reversed because disparities exist. When we look at the history of this country, you know that disparities exist. Intentional discrimination may not always be something that we can prove. But what you can show sometimes with a good lawyer is that there was a disparate impact on one particular group of employers over another. So therefore, while the company's policies were race neutral, did not seem to be, it was for everyone, had the requirement. They seemed to be race neutral, but at the end of the day, the policies the court held had a discriminatory impact, the disparate impact theory, on African-American employees. And those African-American employees were the 13 men from Eden, North Carolina, that every family member here tonight should hold their chest out and be proud. And not only proud, it should really carry you far, and all of us, to know just how these men in your lineage, for those of you who are related, how they stood up, and they stood up to make a better life. So that's where I'll end with this. One final point, the act does not, and this is a point that I need to make, it doesn't prohibit the use of testing procedures or high school requirement or other job requirements. That's what needs to be clear, because people resent often if they think a company can't impose requirements for qualifications. That's not what the ruling said. It doesn't prohibit that. It just says that those requirements cannot be done or presented in a way that has a disparate impact on one group of people, which would ultimately violate the Title VII and be in contradiction to this landmark decision. So that's, in essence, in the best way that I can break down in a very narrative understanding for everyone, what the disparate impact is about and what Griggs versus Duke Power was about. And thank you for allowing me to present on that tonight. I hope that that was helpful, and it was my pleasure to speak to you this evening. And I'll turn it back over to Matthew.
Thank you, Cynthia, very much for your extensive insights and knowledge into the legal aspect of the subject. It's certainly a subject that, when seen in the wider context of US history, as you've mentioned, can seem quite vast. And so for the museum, at least from our point of view, the MARC, distilling all of that information into a coherent exhibit that can still convey those important messages, the important history, and resonate also with visitors on a human level is certainly a challenge. But next, I'm going to play you a virtual tour of our new exhibit. It lasts roughly about 14 minutes. And not to tempt fate with how my Wi-Fi is kind of panning out tonight, I will probably turn my video off whilst I share my screen. But hopefully that will kind of explain how the MARC tackled that challenge, as well as giving you an exclusive first look. So let me just share my screen, and I'll probably ask you in a minute, Valencia or Cynthia, if it isn't showing for yourself. Bear with me.
Hello, welcome to the Museum and Archives of Rockingham County, otherwise known as the MARC. My name is Matthew Titchiner, I'm the Executive Director, and today I'm going to take you on a very special virtual tour of our newest exhibit, Heavy Other Scales, Griggs v Duke Power. Our newest exhibit recognises and celebrates this landmark civil rights case where, in 1971, 13 African American men from Rockingham County risked everything to fight for workplace equity and won. Now, exactly 50 years on, at a time when we are all taking stock, re-examining our rich and complex history and reckoning with the sometimes difficult legacy history leaves behind, it has never been more imperative for cultural spaces like the MARC to stop, listen, and uplift these sometimes marginalised footnotes of the past. A new exhibit lies in our Civil Rights Room, which, for those who've not visited the MARC, situated in the old county courthouse, the room charts the history of Rockingham County activism and achievers fighting for equality. The room teases out the threads that run from the early freedmen with the aid of personal historic objects, through desegregation, changing attitudes, and how Rockingham County fits with the national story. Talk of civil rights, and most people will think of the iconic Dr. Martin Luther King Jr.'s I Have a Dream speech, given at the 1963 March on Washington for Jobs and Freedom. But not as many people are aware that after his assassination in 1968, the civil rights movement did not suddenly end there, and nor was true equity achieved. But this is the way that it is often taught. By readdressing this convenient historical bookend to the way we teach the civil rights movement, we hope our new exhibit will demonstrate that struggles for equity continued long after towering figures like Dr. Martin Luther King Jr. Distilling the last few years of research, the new exhibit breaks down the case into 4 main sections: the background, the complaint, the decision, and the legacy. To give context, the 13 plaintiffs in Griggs v Duke Power lived in a world segregated by race. During the Jim Crow era, African Americans were routinely only hired in the lower paying jobs. This occupational hierarchy has, by many historians, been identified as one of the main pillars of the Jim Crow racial caste system, with African Americans actively limited to the lower rungs of the labour force. In the mid-1960s, at Duke Power Company Steam Station in Draper, North Carolina, which is now Eden, had hundreds of employees. Among those, the would-be plaintiffs all worked in the Labour Department, listed as janitors. But despite their experience and their proficiency, even filling in for other departments when needed, they were routinely denied promotions and transfers within the company, and also suffered a stark pay gap with other company departments. Duke Power Company, like so many companies at the time, introduced arbitrary intelligence tests and requirements, such as a high school diploma, for those wanting to work outside any of the departments other than general labour. These tests had little bearing with the advertised jobs, or about selecting proficient candidates, but disproportionately impacted African American workers. On top of which, white employees were on many occasions promoted without a high school diploma. By 1966, 81 of the 4 higher paying departments of coal handling, laboratory and tests, operations and maintenance of equipment were all white. Encouraged by members of the local Reidsville chapter of the NAACP, especially its president James A. Griggs, the 13 plaintiffs put their families, their safety and their livelihoods on the line to fight for greater equality and officially challenge these employee requirements. Claiming that they were unrelated to job performance and requesting the right to promotion when vacancies should occur, the claim was filed officially in October of 1966. And behind me here, you can see the signatures of those men on an image of that original complaint document. Signed by Junior Blackstock, Willie Boyd, Eddie Broadnax, Eddie Galloway, Willie Griggs, Lewis Hairston Jr., John Hatchett, Clarence Jackson, Robert Jumper, Herman Martin, Jesse Martin, Clarence Purcell, William Purcell, and James Tucker. All but Jesse Martin would go on to fight the case in court. Jesse had a high school diploma from Booker T. Washington High School in Reidsville and was promoted to the coal handling department 2 months before the case went to court. Little did the 13 men know then that their case would be a protracted one and go all the way to the top. Represented by NAACP legal defence attorneys led by Julian Chambers, it took nearly 5 years to work its way through the court system until it was finally heard before the US Supreme Court in December 1970. For those visiting the MARC, QR codes like this one will take you to a host of resources related to exhibit content. This one will take you to that very US Supreme Court reading in 1970. Let's listen to a clip.
Mr. Greenberg, you may proceed.
No employer, we submit, under the statute, is required to employ anyone who is unable to do the job. And any employer may use tests and educational requirements which predict whether an employee or a prospective employee can do the job. But if the test that's used or the educational requirement that's used screens out members of a race or of a group protected by the statute and does not predict who can do the job, then it cannot be justified merely on the basis of good faith.
Thank you, everyone, for your patience. It seems that Matthew's internet again has ended. So while we're waiting, hopefully he will reconnect. Just a couple of questions that I'm seeing. Questions about whether the recording is going to be available. Yes, the recording will be available. Matthew said that it will be on the museum's Facebook page and website. I would like for everyone to give grace and flexibility. And let's remember that the museum only has 3 paid employee staff, okay, that's working. And everybody else associated with this program has volunteered countless hours and their time to get this done. So just thank you. Oh, here he is. He's back.
Yeah, apologies again. Honestly, I've never had so much trouble. It's typical, isn't it? When you need it to work, it does not work. No, the MARC isn't open yet. We haven't got a fixed date when we might open, unfortunately yet, but hopefully not too far in the future. I don't know where we got up to with the video.
I think we were almost at the end.
Okay. Yeah, I do apologize again, everyone. This will be shared with our Facebook page. It'll be on our website as well. I mean, this is the first time we have done a virtual event like this. And foolishly, in my naivety, I thought, well, my internet at home will be much better than the museum. Well, obviously not. So maybe next time I'll do it at the museum.
Cynthia, are you still on the?
Yes, I am, Valencia.
There's a question, and I think it's directed towards you. Were there any financial related recovery for the plaintiffs, and how long did they each work for the company after the decision? So I think that first part.
Yeah, I think, I don't know many of them had retirement accounts and some stock options. I know a few of them got a few stock options, but I think they got that just through their longevity in the company. This was more of relief as far as promotion. Some of them were promoted out of the labor department. Most of them were. And so that was the remedy that came to the ones who were still there. More of a what we call injunctive type relief, where they're moved out of their current position, as opposed to more monetary relief. But by being moved to a higher department meant getting a better pension. Also, as I said, some stock options and other things that they were able to acquire in later years. And I know that a few of them stayed with the company for almost 30 or more years.
Yes, from my reading, the only one that I've read so far that actually left was Willie Griggs. Yeah. I can't say that everybody else stayed and retired from Duke Power. I can't confirm that, but most of them did retire.
They did, but some of them retired shortly thereafter. Like the decision was 1971, and some of them were only there for a few years after that. But you're correct, Valencia. They were there until retirement for the most part.
And I think one of the things that when I started doing the research was realizing the age of the men when I started. So that was something to impact. So yes, by 1971, most of them were at the end of their career. I am scrolling through for questions. Statement, if you're not following the chat, I know some of us are listening by phone. It says Mr. Willie Griggs did not retire from Duke Power, and there was only a small compensation that he was given, and he retired from Fieldcrest. Okay, so I didn't know that. So thank you for sharing that. I didn't know that. So I'm adding to my notes.
For clarification, did he, whoever spoke on that, some of the reported accounts said that he got a small retirement from Duke Power and then maybe went on to another company. As I said, most of them left shortly thereafter. But did he get a small pension, I believe, from Duke Power also? Some of the records are unclear, but I'm pretty certain that he got something for the years he'd been there.
All right, so I guess another question. Were any of the 13 men and their families harassment because of the case? Someone's just finished watching Billie Holiday and Judas and the Messiah, so they're all up into their Black Power movement right there with that. I haven't spoken to every family member, and I haven't made connections with all of them. What I did find out is that a lot of what happened to them personally and to their families, we may never know because they never told the stories. Some families didn't even know about the case.
Yeah, a lot of the men from that generation, they were actually called, like today we call generation of millennials, they were actually called the silent generation. And literally that was the right term. Those men really didn't talk a lot. And that was part of the protection for their families. And remember, men who grew up in that generation were actually most of them were taught, you don't say much. You say a lot, you could get hurt, especially in southern states. So they were very silent and didn't talk much about the case, which is why we had hoped to talk to many family members to develop some personal stories. And I've only had a chance to meet with one, hope to maybe meet with some others. But you know, if you would love to, if you have some memories and you'd love to share some of your family stories, just because we're at the anniversary date doesn't mean that we cease trying to honor the men here. So get in touch with Valencia or with me.
Yeah, absolutely. While I'm kind of here for the moment, yes, just to kind of summarize, again, apologies, not how I expected tonight to go down, but I will be sharing that video. We did have some of those clips, edited clips from those interviews that the museum did carry out. And there were some, you know, really poignant, really fantastic things in there. And I think, again, you've already said it, Cynthia, you know, a lot of the families didn't know about the case until later in life, in college, reading it in a textbook and thinking, oh, well, that's my family, you know. And it's those kind of, it's hard to imagine, but those kind of revelations that really help people understand and really connect with the exhibit, which if the video had held out, shows not just the case and its impact, but workplace equity in general across the US. We have a timeline in the new exhibit that kind of charts that right from the enslaved right through to modern day. And so that all kind of helps people get into the mindset of where Griggs fits in with the wider context and what it led to, and how Griggs came about. In the exhibit, you do have a little dress-up corner, as well as the 70s trivia in there to get some of our younger audiences whose 70s might appear more like ancient history to them. I'm sure some of the school children coming through, it will hopefully get them in the mindset of what the 70s, or give them a taste of what it might have been like. And there is a chalk wall in the new exhibit as well. So people can write messages to past activists and present fighting for equity and advocating for that. Visitors' contributions will become part of the exhibit as well. Yeah, this is something, as you've said, Cynthia and Valencia, we want this to continue. We want the awareness to continue. We want to spread that message and also reach out to more and more family members and make those connections and preserve that history.
There's a couple of questions. One of them was about the NAACP. It says, do you think that there might be minutes from the NAACP meetings of that time and that might mention what was going on at the case in any point along the journey? I am currently going through the Reedsville branch of the NAACP. I've been doing that for the last couple of weeks. At this point, the answer is no. So other than the statement, which you will see a photocopy at the museum on the exhibit, there's nothing during the time that the case was in the legal system. What I am finding is interviews from newspapers after the fact. And one of the things that I was surprised about, the banquet, there is no mention of the Griggs case at all. And then I found the pamphlet for the 1972 NAACP banquet, nothing so far of the Griggs case, but that's an ongoing process for me. The record keeping isn't like the best, so I'm basically going through each file, but so far there's nothing during that time, and that's sad. But I may be able to find something. As of right now, nothing.
I'll add to that, Valencia, that you're right, in the North Carolina, well, the local NAACP chapter, like you said, there's not much there that was archived. But remember that the case it started out with attorneys Julius Chambers and Robert Belton in North Carolina. And then when it got to Washington, there were other lawyers who handled the Supreme Court opinion. So that then turned over to the Legal Defense Fund of the NAACP, and they have records. And in fact, if you even go to the NAACP LDF, which is the Legal Defense Fund website, you'll see some postings about the case. And they have quite a few records and documents there, but that's more about the case, not about the men in particular, not necessarily notes about personal interviews, a little bit there, but mostly about the Supreme Court decision.
Yeah, And even with newspapers, I know that the reason for review, I was told that there was a fire and that they lost a lot of that information. But even newspaper searches during that time is not giving us a lot of information. My assessment is, I don't think they realized what was going on, or they didn't realize the importance of what was going on. With that. There was one more question and I didn't, it says, can there be more PR? I don't know what PR means. PR for the family members who wish to participate. Are you talking about connecting with the MARC? If that's the case, we've been trying for almost 2 years, and the information, there's a phone number, there's an email address. We're actually collecting oral histories for this, so we will be happy to do that. Just contact Matthew at the museum and set something up. We are trying to collect as many histories as possible with that. So, and there's family members that we haven't even gotten in touch with yet. So if you know of somebody that knows somebody of these 14 men, please just let them know.
Yeah, no, absolutely. And the actual oral histories, we record all of the interviews. I mean, it's been via Zoom until this point because of the pandemic, but certainly going forward, we may even be able to do some in person if restrictions eventually are reduced. But we keep those in our kind of bank as preserving history. And then we use edited clips, and they play as actually a central part of that new exhibit on an analog television, so people can actually hear from the relatives themselves, and it really helps add that humanizing element. It really kind of shares their stories.
Question was, how did the group first contact the NAACP attorney who brought the case? Interesting story is that James Arthur Griggs was the president of the NAACP, and he was friends with Willie Boyd. And the history or the stories that I'm reading, Mr. Griggs got tired of Mr. Boyd complaining and told him to do something about it. And that's how it occurred. And because they're with the NAACP, then that's how they were able to make those connections with the attorney.
That's what I know about it as well, is that through it came through the connections and the knowledge of someone who knew the actual attorneys involved. So,
yes. And on the Facebook page that I'm running, there is a whole post about the attorneys, because I thought that was interesting and the history that they bring to that. So please just find me on Facebook, and it will connect you to the civil rights page of Griggs versus Duke Power, or you can just put it in Facebook and go to that. Yeah, but there's a whole section that I did on that as well. How can we, families of the families of the great men, help support MARC and amplify these incredible stories? Before Matthew answer, I'm going to answer because Matthew is really nice, but support the MARC. I mean, become a member. When I said that there's only 3 paid staff employees, I'm not one of them. Professor Tompkins is not one of them. So many people have donated hours and hours of their time of this. So I would say become a member, volunteer when we open up, volunteer to help out, not just with the Griggs, but just come in and volunteer. There are archives. There is so much work to be done. All right, Matthew. I'm gonna be quiet now.
Thank you. Yeah, I would second that. We are always in need of volunteers. I mean, as Valencia has already said, we are a small team, made smaller by the pandemic, unfortunately. And we do rely on volunteer efforts for most of what we do. Our archives are very extensive. We have a lot of work that we're doing in there, but we also need people to help out with various committees as well, you know, if that would be something that people would feel interested in, you know, whether it be programming, whether it be publicity. There are plenty of things on our website, volunteer wise. Really just get in contact with us. Sorry, Valencia, like you're going to speak.
No, I was going to say thank you to Fatima for posting. She is so awesome. Speaking of volunteers, she is one of the college interns. So she has been monitoring the chat, and she put in the link to the Facebook page. And like I said, she's just totally awesome. Another question that says, what's the likelihood that Duke Power would issue a formal public apology?
I am not sure about that, but certainly towards the end of the video that I did create, and we do have in the exhibit a thank you board. You know, Duke Energy have assisted us in the efforts of this, looking through legal records, and that's still ongoing, trying to find what they can in terms of material evidence. They, you know, have recently put up a grant of $1 million towards organisations fighting for racial equity. And many other projects on their website, which obviously is very different than what was the attitude in 1971. In terms of kind of other thank yous, I just want to quickly mention as well before we kind of move on to any others. Obviously, Valencia, thank you so much. I'd like to thank you, you know, on behalf of everybody from the museum for not just spearheading this project, but all the hours, the dedication on top of your teaching and everything else. You know, I can't thank you enough. Really, it's amazing what you've been able to do and what you've been able to find, and I'm sure we'll find some more gems as we keep going. And also thank you to the town of Wentworth and the Reedsville Area Foundation for awarding MARC the grants that enabled us to do this exhibit. Thank you to them, obviously to Cynthia as well, and to everybody who was involved, all of the MARC team. There's so many behind it. It's hard to put into words, but it really is a team effort. And so kind of going back to that original question, you know, there are so many ways that people can help the MARC and help this effort and really reach more people than we even have done tonight. So thank you.
There's more questions coming in, and I think Matthew said that the questions we didn't get to answer, you're going to address on the Facebook page. Was that correct?
Yeah, you can email the MARC either at info@themarconline.org. Facebook is also another way we can do it. We have a Facebook page. You can just message us on that or through our website as well. So there's many options where you can ask us questions.
And I want to say thank you for everyone participating. I got more information, which means more research. So thank you. When I titled this a passion project, it's definitely a passion project. And this isn't the end. Actually, I think this is the jumping off point for us to go wider and deeper into this history. So thank you.
Thank you. So yeah, again, apologies for all of the technical issues on my end, but I will be posting that video, and so hopefully you'll be able to see all of that and really get a sense of what the exhibit's like. So thank you very much for everybody joining us tonight. I hope you've enjoyed it. I hope you've learned something new, and thank you to all of our panelists today, and thank you, Fatima, for doing the questions. That's been great. That's been really helpful. So yeah, thank you, everybody.